Hey, gun people. Yeah, I want to do a follow up. Somebody put a link in here about this letter to the DA. I didn't hear about this. Um, this sheds some lights, and I'm going to kind of explain it, hopefully in layman's terms, for people that aren't in the profession that understands the DA and the cop relationship. So this video ain't going to be exciting, and nobody's going to get shot or killed, but we're going to talk about this cop that shot the other cop. So according to this article, uh, the prosecutor. Now, some places, some states call them a circuit attorney, a city attorney, a district attorney. Usually, that's the prosecuting attorney. So this prosecutor for St. Louis, Kimberly Gardner, sent. I'm assuming it's the chief, Colonel John Hayden of Metropolitan. So I don't know. Notice the colonel rank when police department starts using military ranks. I always call that a clue. The militarization of our police to take over the citizens to where they don't work for the citizens, but an occupying force, things of that nature come to mind. But I digress. Let's stay on the city attorney letter. So let me look at this letter here on what it looks like. So I'm going to read what it says, then I'm going to tell you what I think is meant by it, and then I'm going to tell you what the attorney is saying inadvertently, and then what the PD is doing inadvertently or on purpose, trying to cover it up. All right, so the DA sends this letter, and for some reason, she sends it also to Judge Edwards, Public Safety Director. I'm not sure what that means. Is this person a circuit judge? Maybe somebody in St. Louis can explain why the DA is sending this to. If this is a sitting judge, then I can see if she's going for a warrant or she's going for some type of injunction or she's going to tell him she's taking over the case. The thing with prosecutors and police departments that a lot of people don't understand is the DA can technically take over a case because they're prosecuting. They didn't used to be. Before they started giving DAs power, DAs were pretty much at the whim of PDs. And if the police department said, screw you, we ain't doing something, the DA had no recourse. Then the DA starts saying, you know what, we need our own police force because government always likes to grow and we always need more cops. And everybody in government always likes people with guns around them, although they don't want the citizens to have guns. But I digress. Let's stick to this. DAs got their DA investigators, so they wanted their own police force. So police departments could not tell them no anymore. They could just say, you know what? My guys are going to investigate. We've got powers to go get a warrant. If you don't want to go get a warrant, we got powers. A sitting DA can't go get a warrant. Warrants have to be done by peace officers. They have to be done by cops. So prosecutors can't get warrants. They can review warrants. They can write the warrant up and give it to the cop, but the cop has to present it to a judge with a probable cause statement, affidavit, and everything that goes into a warrant. So DAs can't do it. If DAs could do it, then maybe, they'd probably say, you know what, we're going to do all warrants because you cops are screwing up. Only we're going to do warrants. They've kind of done that a little bit by putting in the review process. When cops do, most agencies, if you do a warrant, you have to have a DA sign off on it. And the reason the DA has to sign off on it is any evidence or fruits that you're going to get from that warrant, they want to make sure they're going to be able to use, and they don't want to lose it because the warrant was bad. So at the bottom of most warrants, there's usually an approval. In Sacramento and in other counties I did warrants, the judge would actually ask what DA approved this. Now, some judges didn't like some DAs, and they would find something wrong if they didn't like the DA and kick it back just because the DA approved it and they don't like him. And then if they like the DA, they would approve it even if it was a weak warrant. So there's still politics and favoritism and, backdoor deals between cops, DAs, law enforcement, whatever. So this prosecutor writes the attorney and says on the press, I want to expect my condolences. She starts out pretty professional letter. She starts out, remember they always kiss you before they screw you? Well, she starts off kissing him while we're really sorry about this. And then she goes, my team and I, meaning the DA investigators, went back to the DA and go, yo man, these cops are stalling us. They're screwing around. They're messing up the investigation. So she says, my team, meaning her cops, and I are committed to getting to the truth, pretty much telling them that we're going to find the truth, so don't interfere. I'm sure you would agree. Okay? The purpose of this letter is share my concerns. That's not the purpose of this letter. She's not sharing her concern. She's telling you, look, I'm putting it on record. You guys are screwing up this case. It's documented. You're on notice, and either you correct it or I'm going to correct it and you're going to look bad. That's the purpose of this letter. But she said her purpose is to share my concerns about your attempts to gather specific evidence on a crime Thursday morning. A prosecutor and 2 investigators. So some DA agencies, if they're big, the on-duty prosecutor will come out to the crime scene when there's a major case. Officer-involved shooting, a death, because they know it's going to be a big case. Probably the prosecutor that came out is going to be the prosecutor that's going to be prosecuting the case. And by coming out and seeing the scene and seeing the witnesses and seeing the investigation, it gives them a better idea when they're on the stand talking to the jury and prosecuting a crime. There's pros and cons to this. Prosecutors come out and sometimes they infect the crime scene. They start directing things that they shouldn't be directing. They start talking to people and asking questions. Then they become witnesses in their own case, and a prosecutor can't be a witness in his own case. So what happens is a prosecutor will run around, pain in the ass prosecutors, will run around, ask questions, get all this great information from somebody, and then they'll run over to the cop or the investigator and go, hey, I need you to go take a statement from them. She just told me this, this, and that. Okay, well, technically, if she just told you that, now you're a witness to what she told you, and they don't want you to put in there in the report, prosecutor so-and-so came up to me and said that he was told by this witness so-and-so, then I went and interviewed a witness. They don't want that. They just want you to go interview the witness and keep them out of it. So there's this kind of pressure to work with the prosecutor and be a team player and not put them in reports. Even though it's flat out wrong, a good defense attorney should be asking. Anytime a prosecutor's on scene, the defense attorney needs to be asking, did the prosecutor talk to you directly? Did the prosecutor ask you any questions? They should be asking the officers. Officer, did the prosecutor direct you to take any statements? Did the prosecutor tell you anything that you put in your report to make sure put in there? They don't ask those questions because lawyers don't like to make other lawyers look bad unless they don't like each other and it becomes personal. Then they'll do it. But I digress. Let's stay on this. Prosecutor and 2 investigators from my office of dispatch to the shooting. At the time, members of our team had a conversation with Major Sack, Lieutenant Brown, and Lieutenant Green. Well, can we get more government on scene? Let's see, we got 4 cops that are shooting each other, and I'll put a link in the description if you didn't see the video. I'll give you a quick brief in case somebody comes here. 2 cops on duty. They go to the home to one of the cops' house that are on duty. An off-duty female officer comes over. There's 4 officers there total, 2 on duty, 2 off duty. They pull out a gun. They start messing around. They play Russian roulette. One cop fires in the air. It doesn't go off. The female cop takes the gun, points at the cop, points it at his chest, pulls the trigger, and it doesn't go off. And I'm sure the cop that was sitting there when she pointed a gun at him had a bulletproof vest on and went, holy shit, you just pointed a gun at me. You're crazy. He probably snatched a gun, turned around, and go, I'm going to point it at you. Bang, the gun went off. He killed her. Now he's charged with homicide. So this is a case to where you want to do a real thorough investigation because you want to make sure, was there a pre-existing relationship? Were these 2 cheating on each other? Were these 2 involved in a major case where they could have lied? Is there a major prosecuting case where drugs were missing or where a suspect was beat up or they covered each other? Are these 2 working together tightly? Or are they having a private relationship? Did one of the spouses find out that they were sleeping with one of the other spouses? So there's all kind of factors that you want to make sure and find out in this case. Well, evidently, Major Stack, Lieutenant Brown, Lieutenant Green, 3 freaking lame administration officers are on scene, not to mention probably the 14 other cops, plus the 4 cops involved, and a prosecutor and 2 investigators. So government was Johnny on the spot like usual. As soon as somebody's dead, government's always there afterwards. Everybody's got their chalk ready to draw the lines. All right, so Lieutenant Green about our desires to have blood drawn for testing of the on-duty officers. So there's a thing in different states are different. When anybody in California, if you're arrested for a felony, there is law that any cop can take a felony blood draw. And the reason the law is in existence is when you commit a felony, we want to make sure that you don't know, or you're not going to be able to come back later and go, I didn't know what I was doing. I was under the influence of drugs. So a felony blood draw does a few things. One, it prevents you from saying you were under the influence if you weren't. Two, it shows if you were under the influence and how much you were under the influence. And three, it just shows a thorough investigation. You're gathering evidence, plus you get to collect DNA and keep the blood and all this other stuff. So there's all kind of factors on why you'd want to draw blood. When on-duty officers are in a shooting, it's always standard procedure to get blood from them. You don't want the family suing, saying, I think the cops were under the influence. And you go, well, we don't think they were. Well, did you draw blood? No. Guess what? They're going to say, you blew it. You didn't draw blood. We're going to side with the victim. They must have been under the influence because you didn't draw blood and you're incompetent. So, why is blood an issue? It's a standard operating procedure. And when they say, we expressed our concerns to have blood drawn, basically they were saying, hey, make sure you get blood from the two on-duty officers. And like most government, they don't like other government. They like pushing around people. They like pushing around taxpayers, but they don't like other government. No agency likes another agency telling them what to do. No agency likes to report to another agency. When you get prosecutors and state police and local police and county sheriff, they all don't like other agencies telling them what to do. So the three lieutenants and everything, I think, blew them off. They did not take blood. That's an error. And that could be, and this DA could be setting them up for saying, you know what? If we find out that there is a deeper motive here and you guys try to cover it up, we're going to charge all three of you with conspiracy to obstruct and cover up a crime for failure to take blood. It may not get a conviction, but you know what? She can charge them. Let's see. Our team asked your staff to work and produce probable cause statements required for searching pursuant to the blood draw. So it sounds like in that place they need a warrant to draw blood. In California, you don't need a warrant. If it's a felony, it's a felony blood draw rule. You just draw blood. You don't need a warrant. Maybe in this state you need a warrant. Probable cause on scene that drugs and alcohol may have been a factor. So she pretty much said that, look, according to things on scene, we think drugs and alcohol was a factor. That's even more apparent on why they should have drawn blood. And the fact they didn't tells me they are conspiring to cover up. They are playing the blue line and they are trying to protect these officers. All right, let's see. My staff was told by Major Stack that your department would see about getting Guardian out. Guardian must be a local blood draw team. We called them, we'd always ask for the vampires, send the vampires out. And they would come out and draw blood. Maybe they use Guardian as some contract city that comes out and does all blood draws for the PD. So we asked your department to see about getting Guardian out to do the blood draw on the two officers, and they would let us know if they needed a search warrant. Consequently, we began preparing a search warrant to have blood drawn. So the DA is saying, you know what? Not only were we there, not only did we tell you we want to draw, we actually did a freaking warrant, and you idiots still didn't get blood. Working closer and closer on the conspiracy theory here to obstruct. Shortly thereafter, Lieutenant Green informed one of my team members St. Louis Hospital would not honor a search warrant to draw blood. So it sounds like, and again, I'm reading between the lines here, it sounds like they took them to St. Louis University Hospital. Maybe they knew they wouldn't draw blood, maybe they didn't, but they took them there instead of calling Guardian like they had suggested, and now they said they're not going to do it with a search warrant. Some, again, hospitals are always fighting. If you remember Nurse Wobbles, Weebles, whatever her name was, they're always fighting with the cops on who knows the best and who knows the law. Maybe this hospital is like, you know what, we don't care if you got a search warrant or not. We're not drawing blood. We're not forcing to draw blood. If somebody says no, we don't draw it. California, we'd strap them down. Somebody told me to change, but we strapped down many people and took blood forcibly when they refused. And I know you're going to call me a bootleg jack. What? Look, it was procedure. It was legal. It was authorized, and we did it. So, and I'm not talking about we didn't do it to family members and people out making a living. We did it to hardcore gangbang thugs that were killing and murdering people. So when we did it, it was a serious crime. It wasn't because some dude walked out, tripped on his front porch, and a cop drove by, couldn't find a speeding ticket, and so he ran over to the guy and arrested him for being drunk on his front porch and wanted to hold him down and take blood. So put it in context, people. All right, I digress. Let me get back on it. This procedure is common for all criminal investigations. It sure is. Later, at the police department, my team, notice that team, everything's about team in government. It's team, 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 unless you're working against another team. All right. Was in the presence of Lieutenant Brown and Detective Strong and others, and my prosecutor was told that a sample had been secured of the involved officers. Now, this gets kind of pretty closer to obstruction. You told it, we told you we wanted it, we told you how to get it, and we started to do a warrant, and then you told us you had blood. When in fact they didn't have blood and they never took blood. A few minutes later, one of my investigators asked again whether the blood draw had occurred, because the investigator was probably a cop, and he's kind of like, these guys are bullshitting us. I don't believe it. They're blowing us off. I want to make sure that they say the blood draw is drawn. My team was told that a breath test was taken as well as a urine in lieu of the blood. Now, when you have blood, a lot of things happen. One is you can take further tests later if it's needed. You can also keep a sample in case they need to do, someone else wants to test your test results. Blood always gives a more accurate reading on drugs and alcohol than urine or breath. Breath is the most unreliable. Urine is second, and blood is the strongest. So what did they take? The two lower ones, and they did not take blood. Why? I don't know. Is it a cover-up, or are they just incompetent? It's hard to tell. Sometimes incompetency appears to be a cover-up. On Friday morning, during an investigation meeting among members of my office, the highway patrol... Oh, shit. Why's the highway patrol there? Ain't no damn cars involved. What the hell's the highway patrol there? Whatever. And your department were told by your staff that Internal Affairs had collected a urine sample breathalyzer under Garrity. Now, Garrity is I can't remember. I don't know if it's a new ruling. I've heard it before. It has something to do with a Peace Officer Bill of Rights, I believe. I haven't looked it up. Let me pause and look it up. Okay, Garrity is a New Jersey case. Garrity versus New Jersey involved a couple cops. They were caught, charged with fixing tickets. They were asked questions, and they were told if they refused to answer that it could be used against them, but they were told they would lose their job. There's a similar case in different jurisdictions of different courts that say because cops can lose their jobs when they answer questions, any statement they give will be deemed to be coerced, and you can't coerce a statement. Otherwise, if it's coerced, then it's no good. If you take a statement through force, fear, intimidation, threats, etc., you can't use that statement. It's deemed unreliable. The courts don't want to encourage cops to do that, so it's thrown out. Well, when you ask a cop a question and it's like, you better answer or you'll lose your job, that's coerced. So by bringing up Garrity, they pretty much locked in these cops. Nothing that the cops gave can be used against them. So that's why the prosecutor's pissed. Now they have no blood, and they have nothing they can use because the cops knew they were protecting cops, so they took it under this Garrity rule, which means, you know what? It was coerced. They gave it so they wouldn't lose their job. Therefore, it can't be used against them criminally, because if you try to use it, it's going to be suppressed under coerced evidence. So, this is a serious problem. She's pissed. I don't blame her. They screwed up her investigation. They didn't let the cops take it. They didn't get the blood. They covered it up, and then they pulled it under the protection of, hey, it can't be used against you. The police department understood that we wanted blood samples for the purpose of a criminal investigation. See, the difference between criminal and Garrity is a department run internal. and this is a criminal. Now, I'm sure the prosecutor knows this, and you guys may not know this. None of this matters if they get charged federally. So what the DA may do is if the case is, if this comes out to be a good cover-up and it's a strong case, in order to get the blood or get the urine and breath test in, she could have the feds do it, and the feds don't care about this. The feds let all evidence in. They have much lax evidence restrictions, so they let everything in. So then the feds can use everything they took. They don't care about Garrity. All right, taking these tests under the cover of Garrity appears to be an obstructionist tactic to prevent us from understanding commission of the alleged crimes. We have an expectation those tests will be turned over to our office immediately as our ongoing investigation. All right, here's where the fight's going to start. She's saying, we want the test, turn it over to us. They're going to say, we don't have to turn it over to you under Garrity. We took it under this. And even if we give it to you, you can't use it. Now, the DA is saying, you know what, we don't care if we can use it. If we can get it, then we can work around that and figure out if they're lying on where they're drinking, if there is drugs, where did they get the drugs. We can make the case in other ways. We just want to know what they had in their system and how much they had. So, in another concerning matter, when my office received a call regarding the officer-involved shooting, 2 of my team members were told by Lieutenant Green that the shooting was an accident. It was reported as an accident by Colonel Hunter later that morning, and then characterized as a mishandling. So the prosecutor is pissed off that they've already made a determination. Normally the DA will decide what the crime is and who charges. Cops just kind of, we do our investigations, we put down what we think should be charged, the DA reviews it, they have to prosecute it, and then they'll go over it and say, all right, we're going to charge this, we're going to charge that, we're not going to. That's why the DA, all cops always charge resisting arrest. And most DAs never charge it. Why? Because it wasn't resisting arrest. Now, there's a bigger problem there that cops ought to be held accountable when they start charging things or alleging crimes that aren't crimes. There's either a training issue, there's either a cover-up issue, or there's a manipulation of the system issue. But that's another video. I digress. Let's get back on this. I'm trying to stay on point. All right. In my opinion, it's completely inappropriate for investigators to approach a crime scene early in investigation with a predisposed conclusion of a potential outcome. And basically, the cops went there saying, holy shit, man, you shot him? Oh, yeah, it was an accident. All right, dude, we're going to label it as an accident. We're going to say it was mishandling. And they got behind a blue line. That doesn't exist. All the cops will tell you, there's no blue line. Okay, whatever. All right, in particular, troublesome given the force investigation required. I understand the need information to the public, so now she's trying to tone it down and not threaten, not come off too much. Labeling any criminal incident prior to full investigation is violation of our duty and objective as fact finders. Pretty much called them idiots and said, you guys are freaking stupid and screwed this up. St. Louis community dams the truth, demands heart. There are other issues that I want to discuss with you in this case. I would therefore like to sit down. This is a nice way of saying we're going to sit down. And have you two discuss this matter as soon as possible. It's important we utilize these incidents as learning opportunities for officer-involved shootings. This is a hint that she's going to change the protocol for officer-involved shootings. Because now when there's one, instead of letting them come over, they're going to say, you know what? When the DA gets there, we're taking over the case. You can assist, and you may be able to shadow us, but from now on, the DA is doing the case. That's what's coming. I can predict it. All right. I will have my assistant arrange a meeting. So there's going to be a meeting. So anyway, I just wanted to give this a short letter from the city attorney. This is what my take is. This kind of gives you a better idea kind of on what goes on behind the scenes and what people are really talking about and what's meant in these letters. And a letter may sound nice. If you just read this letter, it sounds like, oh, there's a couple little mistakes and the attorney's just trying to get to the bottom of it. No. The DA is pissed. She knows they're following up. She knows they're screwing around. They know they're screwing around. They've bumbled the investigation. They've obstructed the investigation. And now there's going to be issues. So, you know what? It is what it is. All right. Hopefully you got something out of that. We'll end that there.